When we first thought about having this event tonight, it was really following the judicial review consultation last December, which was about sort of quite practical changes to the way in which judicial review is delivered, and that consultation has now been responded to by the government. We had no idea that this completely enormous consultation changing the whole landscape of legal aid across both crime and civil areas and dramatically affecting prison law and judicial review was on its way. So one of the things that we really hope we can get out of tonight is some really good ideas about how we can respond to the consultation and really try and make a difference to the outcome. What we hope to do is each of the panel members will speak for about 10 minutes, and then we really want to hear from all of you. Could I just have a show of hands for those of you who are actually prison law practitioners, just so we know, and criminal practitioners and public law practitioners? Great. Okay, so a really good mix. So we should be able to do some really good thinking around the subjects. I'm just going to cover very briefly now, for those of you who haven't had a chance to digest everything in the consultation, the nuts and bolts of what it means for prison law. We're then going to hear from Philippa, who is going to tell us about some of the amazing cases that she's been involved with that really demonstrate to us what an important driver for penal reform judicial review has been. We're then going to hear about why it may be a threatened species from Martha in relation to the changes planned for judicial review from the consultation. And then we're going to hear from Lena from Paz about the impact on all the sentence cases and the changes to prison law from the Prisoners' Advice Service. So if you could have a look at the briefing in your pack, I'm going to very briefly take you through what the consultation says. So just page 2 there. The consultation response was due by the 4th of June. And we've given you a link there to the consultation itself and the impact assessments. In relation to the extent to which it will affect prisoners, the most obvious change is the change to scope of prison law legal aid. The scope is going to change dramatically. Top of page 3, they want to remove from scope entirely adjudication work where there is no oral hearing. So at the moment, I'm sure a lot of us do appeals, perhaps where people have not had the benefit of legal representation where they should have, including cases where people have had internal adjudications, perhaps because they're life sentence prisoners and they're not entitled to representation, but they may get advice. That will all be gone. It will just be referrals to the independent adjudicator and current criteria cases, which is where a prisoner is considered so vulnerable that they are entitled to legal representation before the governor. I went to a meeting at the Ministry of Justice a few weeks ago and asked a little bit more about this, because in my personal experience, I have asked many prison governors to allow me to come and represent extremely vulnerable, learning disabled child clients at internal adjudications, and I have only ever once been permitted. And when I did go along to represent my self-harming young child client, the adjudicator stormed out after 5 minutes when I asked to make some preliminary points and said, I'm not having any of this. So it's a very sort of small area, and when I asked the official at the Ministry of Justice as to how people would be able to get Tarrant cases if they weren't allowed to make written representations, he said to me, well, surely we can trust prison governors to identify those cases. And there is a theme, actually, that the Ministry of Justice seem to be taking it on faith that norms and that the infrastructure, if you like, of the prison service should be trusted to do their job. And one of the things they're relying on very heavily in this consultation is the presence of a robust system of prison service instructions and orders that allow for a very healthy system that checks and balances itself. So that may be one thing we want to think about in terms of informing the Ministry of Justice of the reality of the situation. The second thing that's going to come out entirely are treatment cases. That's received quite a lot of press, but as most of us will know, treatment cases have been virtually non-existent since 2010, when they became cases that you had to apply for prior authority for. Since 2010, only 11 such cases have been granted. I know I've applied for many, including pregnant mothers who are worried that their babies have been told that their babies are going to die, and have been told that that doesn't meet the criteria for public funding. So that's not a huge change, but it is a significant one, that there will be no flexibility whatsoever in the system for prison lawyers to do that kind of work. And then sentence cases that do not engage Article 5.4. I asked the Ministry of Justice whether sentence cases that engage the lawfulness, liberty itself, 5.1, would still be involved, and they said no. What do sentence cases mean? Well, we're going to hear from Naomi in a minute about some examples of sentence cases, but essentially we're talking about recategorisation, progression through the system, access to offending behaviour courses, resettlement issues, making sure that vulnerable prisoners have somewhere to go when they do get released. I know for myself that 90% of my parole hearings would fail almost entirely if I hadn't been working very hard on a fixed fee, good value sentence case, which I put the effort in to make sure that there is a decent resettlement plan available so that we can argue sensibly for parole. Rocking up to the parole hearing and saying, please let them out, is not really going to do the trick in most of our cases. So all of those things will go. The other enormous change is the delivery of prison law services. Although prison law services won't be subject to competitive tendering, in that you will not have to bid and say, I can deliver prison law services for 5p or 10p or whatever, they will fall under the competitive contract. So every single provider that applies for a new criminal contract in the brave new world of competitive tendering will have to be able to explain how they will be able to provide prison law services. And so they want to bring down, approximately 1,600 providers down to just a small body of 400 providers, or maybe just one provider in terms of Eddie Stobart, we don't know. And then those providers will have to be confirming that they will be able to provide prison law services. Whereas the rest of the criminal tendering process, the country will be divided up into little chunks, and you will only be able to represent clients in that area, and clients will have no solicitor choice. Prisoners will have complete choice, and they will be able to go to any criminal provider in the country and say, please give me my prison law service. And according to the Ministry of Justice, and I have checked this with them twice, that provider will be required to provide that service. There will be no cap on the number of cases that they can provide. And then finally, they won't only have to provide that service, but they will have to provide that service at a knockdown price. There's going to be a 17.5% fee cut. So the prison law cases will be administratively set, but they will be set at a reduced rate. So, moving swiftly on, so that's the criminal legal aid side of things. In terms of civil legal aid, I'm going to touch on it extremely briefly because Martha is going to tell you all about that in more detail. But there are three key proposals that will affect civil legal aid. One is a new residence test, which I think Martha's going to go into in some detail. Two is that practitioners will only be entitled to be paid if they get permission. So the work that they do up until permission will be at risk. And three, cases that have less than a 50% chance of success will be removed from scope entirely. Of course, this affects all judicial reviews, but I think some things that we need to point out in relation to prisoners are that there are going to be some foreign national prisoners that are particularly affected by this. So if you think about a foreign national prisoner who has no immigration status, who is not lawfully resident, who has a resettlement issue or sentence planning issue, can't progress, they won't be able to have a sentence case anymore because they'll have gone from scope. And then, of course, if things get really bad, they won't be able to judicially review the prison either, because they won't be eligible for legal aid. The other thing I suppose to point out about prisoners and judicial review is, of course, that when you're doing these things at risk, if you have a client in the community, you can pick up the phone and get instructions. But of course, if you've got a prisoner client and you need to progress your judicial review, you're going to have to go and visit. So the costs for doing prisoner cases and judicial review are going to be considerably more. So I think I will leave it there. You'll see from the paper that it goes on and on and on. I don't want to do that. So I'm going to stop now, and I'm going to hand over to Philippa. And if you look on the very first page of your handout, you will see a summary of all Philippa's amazing achievements. There we go.
Yes, stop.
There we are.
Stop. When Laura asked me to speak, as she indicated, we were intending that this be a seminar on judicial review and how we could encourage prison lawyers in particular to look at and take more judicial reviews. And it is now, in the face of these extraordinary and completely unanticipated proposals, become a seminar on how to save prison law and save judicial review. An incredible set of changes in the last few weeks, which leaves everybody in this room in an extraordinarily difficult position. My task today is simply to try and show to you how important judicial review has been in the area of prison law in the last 20 years or so. Something that no doubt you all know, but many of you who came to prison law through adjudications and parole hearings, which were established through these cases, might not be that familiar with the history and the process of how those procedural guarantees came to be given to prisoners. So I just want to give you a little perspective on the history, because it's fascinating and it's entirely down to cases in court that all this has come to pass, which has brought us to a position where the government now feels that the legal aid budget for prison law is so great that it wants to make spurious savings. So I want to go back to 1979, one of the first prison cases to come into the courts in a judicial review, and that was the case of Ex parte Saint-Germain. It was a case brought against the Board of Visitors of Hull Prison, because in those days, adjudications in very serious prison disciplinary offences were undertaken by the Board of Visitors, the IMB, as it now is. And this was a JR arising out of all sorts of unfairnesses in the procedures before the Board of Visitors. And the issue in the case was whether or not you could JR at all. Was the Board of Visitors subject to judicial review? And it had to go up to the Court of Appeal for the Court of Appeal to decide yes. The administrative court, well, it didn't really exist as the administrative court though then, but the court was entitled to look behind the closed doors of the prison and to adjudicate upon whether or not the procedures that took place in there to discipline prisoners were fair, accorded with the requirements of natural justice. And it's interesting in that case that one of the questions the court asked itself was, well, what's the nature of this body, this Board of Visitors, when it's adjudicating? Is it like a governor? Is it just an administrative body? Or is it like a judicial body? Does it have a judicial set of attributes that means that we can attach requirements of fairness to it? And they looked at it and thought, well, it's sufficiently judicial for us to be able to say that it requires to act fairly. Now, you just have to focus on that for a second to think about how far things have come in the last, what was it, 1979? So the last 30 or so years, for that question to have been posed in those days. Is it judicial or is it administrative? The presumption being that if it's administrative, forget fairness. You know, prisoners don't have a right to be dealt with fairly in relation to administrative as opposed to judicial decisions. We've moved a massive way, and that is because of the judicial reviews that have been taken. The next incredibly important case in the area of prison law came a couple of years later, in 1982, and it's the case of Raymond and Honey, and no doubt you're all familiar with it, but it's just worth focusing very briefly on what the issues were there. And the very short point which formed the foundation upon which that case was decided. Mr. Raymond, in that case, had tried to send a letter out of the prison to his solicitors, and it was stopped by the prison governor and read. And he was really, really miffed about this. So he then started proceedings, or tried to start proceedings, against the prison governor for contempt for interfering with his access to his solicitor and his access to the court. And the prison governor stopped his proceedings from going out of the prison and being issued. And the reason he did it is because he said there is a policy in the prison which requires you, in relation to any complaint you have against the prison administration or an individual within the prison, to ventilate it with us, the prison, before you take it outside the prison. And he said, well, that's absolutely and totally outrageous. I mean, that is a fundamental interference with my right of access to the court. Why should I have to ventilate it with you before I take it to the court for the court to adjudicate on my rights? In that case, went to the House of Lords, and the House of Lords agreed with him. And it agreed with him because it found prisoners do not, upon their imprisonment, lose any of their civil rights that are not taken away expressly in the statute governing their imprisonment, or by necessary implication of the provisions of that statute. And that has formed a fundamental basis for the development of prisoners' rights and the development of cases in the courts since that date. And we'll come on to just a couple of examples of cases in a moment. Now, that was the Louis Blanc Cooper era. He was an incredible barrister who took incredible cases that were way before their time. He lost nearly all of them. He had some amazing victories. But what he lost, others picked up after him. And one person who picked up and ran with his cases and his ideas and then developed his own in the most spectacular way was Ed Fitzgerald. And he, in the 90s, decided that his mission was indeterminate sentences. Sentences which at the time were entirely administered by the executive, by the Home Secretary. If you were subject to a mandatory life sentence for murder, an HMP, a sentence of HMP detention if you were a young killer, or if you were subject to what was the only other indeterminate sentence at the time, the discretionary life sentence, because you were detained on grounds of dangerousness, then in respect of all those sentences, once you were sentenced, it was down to the Secretary of State to decide what happened to you. Yeah, the parole board advised the Secretary of State when he asked them to, but he had the ultimate decision on when the parole board got to entertain your case for release, and when they got to entertain it, whether you were released or not. He could just ignore the parole board's recommendation. And Edward, together with solicitors at Bernberg's, began to look at, and then other solicitors over time, began to look at these sentences, and he picked beautifully his strategy. First of all, he looked at the discretionary life sentence, and he said, well, hold on, this sentence, it's not like the mandatory life sentence. This is a sentence which has two very clear components. One is punishment, the other is dangerousness. Why on earth is it that, so far as the punishment period is concerned, why should the Secretary of State fix the punishment? That doesn't make any sense. That's a judicial exercise. Sentencing is a judicial function. And through judicial review, because we didn't have the Human Rights Act at that stage, through judicial review, step by step, he got the courts to pick apart the sentence and to engage with what its underlying rationale was, to strip the Secretary of State of powers. So in the first instance, he got the courts to say, you're right, it's a judicial function. The Secretary of State does take the advice of the judiciary already as a matter of policy about what's an appropriate punishment. Now, given the nature of this sentence, he's got to fix it in accordance with the judicial view. And because it's judicial, you can't take account of all manner of different factors. You've got to fix it by reference to what the sentencing policy was at the time. So that was the seed with which he then ran all the way up to Strasbourg to say that we have a sentence to which Article 5.4 attaches, not just when the court is sentencing, but again in the course of that sentence once you have completed the period of punishment. And Strasbourg was able to say, once you've completed your punishment period, there is a new basis for detention. It is dangerousness. And because it's a fresh basis, then Article 5.4 requires that a court must determine whether it's lawful. And that was the way that we then had the 1991 Criminal Justice Act that said Secretary of State has no role to play in relation to this sentence. It's down to the parole board to decide release. It's down to the sentencing court to fix the punishment. Absolutely beautiful. And alongside that, he worked on the HMP sentence. And there, he worked on assimilating the rationale for the HMP sentence to, even though it was imposed for murder, even though for murder at the time the understanding of the mandatory life sentence was this is punishment for life, he got the courts to assimilate this sentence, which is imposed on a child, you can't possibly be punishing a child for life for murder, to the sentence that is a discretionary life sentence. It, like that sentence, has two components: punishment, dangerousness. And again, through what he did in judicial review in our courts here, he was able to have it beautifully pitched by the time he got to Europe for them to say, ah, this is the same as the discretionary life sentence. Now this too must be dealt with in the same way. And we had amendments in domestic legislation, and suddenly all HMP detainees also had a right to an oral hearing before the parole board. And then he was working at the same time on the mandatory life sentence. Step by step, this sentence, which had always been understood to be a sentence which involves lifelong punishment, anything you get less than that is a present from the Secretary of State, a merciful disposition. No, slowly, through the case of Doughty to begin with, where he was seeking to inject fairness into the Secretary of State's tariff-fixing exercise, he was able to make movements in the way that that sentence was perceived, so that by the time he got that to Europe, he was able to overturn a decision of the European Court which had agreed that this was lifelong punishment, and to get them to say 10, 15 years later, no, this is also just like the discretionary life sentence. And that's how we now have parole board hearings across the board for all determinate sentence prisoners, so that when they created the IPP, they knew they had to bring it into this process. And similarly with adjudications, how have we ended up with an independent adjudicator and with a right to representation? Again, it's all been through arguments that have gone through the courts. Ultimately, they had to be argued in Strasbourg, but today, with our own Human Rights Act, they will be argued in our courts of judicial review here. So we reached the completely ironic position where, through all that work, which has opened the doors of the prison, opened our eyes to what it is that is unjust about the way the system is administered, through that we have created these very, very strong, procedurally fair systems of oral hearings and adjudications, and it is those that have led to increased costs in prison. Because 10, 15, 20 years ago, there were about 4 of us ever working in this area, and now it is a massive industry. And that massive industry is what has led the government to say, okay, now we've got to cut the costs. We can't cut parole hearings, we can't cut adjudications, so what shall we cut? We'll cut everything that doesn't relate directly to those matters, to release and Article 5.4 hearings. I just want to, have I got a few minutes, a couple of minutes, 2 minutes? Just a couple of other areas that would now be cut out of scope completely, where incredibly important work has been done in the field or through judicial review. Parole hearings themselves, I mean, going way, way back, it was again through that work on trying to look at what a discretionary life sentence is that we first got disclosure of reports of parole hearings. You didn't used to get them. The prisoner would see and know nothing. So that was something that came in 1992. It then came in relation to HMP detainees as well because of the way they were assimilated. Then we've got fairness. We've got the way in which fairness has been injected through other aspects of prison proceedings, starting with Doughty in relation to tariff fixing, where the House of Lords established a key principle about fairness that has been invoked in cases throughout administrative law, not just relating to prisons, but it's almost routinely cited in any case you want to deal with in relation to fairness. Duggan, Category A decisions, and the disclosure of reasons and the gist. Lord, disclosure of actual reports. Oral hearings in some Category A decisions all come through challenges to fairness. Fairness rights in relation to segregation decisions, the right to have reasons and to make representations. release on temporary licence and fairness injected into those processes. And then going back for a moment, just very briefly, to the Raymond and Honey case and how through the recognition that you can't just invade fundamental rights willy-nilly, but you can only do so where that is a necessary implication of the power you're exercising. We've got cases such as Sims and O'Brien, cases where people who have been wrongly convicted and are trying to use journalists as a means to get their cases back to the Court of Appeal because there ain't no money in it for criminal solicitors to do it on their behalf, and the journalists aren't allowed to come and see them in prison. They're not allowed to interview them. The journalist's point of view is, well, I'm not going to expend God knows how much energy researching a case that may come to naught because this guy's lying. I need to see him. I need to get my measure of whether he's credible to see if I'm going to run this case and investigate. That went to the House of Lords. The House of Lords said it's unlawful to have the rules you have in place that prevent this. Daily, prison officers going into a prisoner's cell and just leafing through his legally privileged correspondence, unlawful. P&Q, mothers and babies, requiring that the best interests of the child are the primary consideration. Childcare resettlement leave. The Howard League's case, bringing the children out right into the prison. All these cases, forget it. Under the new proposals, you won't be able to do any of this. A recent case that I did with the Howard League, where we were bringing a case against a privately run prison, Ashfield, a privately run young offenders institution, where through cross-examination and judicial review proceedings, we were able to uncover the fact that they didn't have a bloody clue in their segregation unit how to run adjudications, what their obligations were. They had no idea, the officer in charge of this unit and of carrying out the procedural obligations of running adjudications before independent adjudications. He had no idea what he was supposed to do because he'd never actually looked at the policies. Phenomenal, unbelievable, and without judicial review, no one would ever have got to any of those truths. So, just to wrap up, judicial review has been, in the prison context, phenomenally important, and it will continue to be phenomenally important. The tragedy is that if these proposals go through, then judicial review will die, inevitably, because insofar as it will still be possible to bring judicial review by way of civil contracts, the connection between those prison lawyers who are continuing to do work under the prison contract and the civil avenue simply will not exist. And prisons will again become totally invisible institutions. And all that wonderful work that has been done in injecting fairness and making prisons think about the rights of prisoners will, I say slowly, perhaps not very slowly, be undone. Because the imperative for governors is not the rights of prisoners. The imperative for governors is good order and discipline within their prisons. And however well-intentioned they are, that imperative is inevitably, over time, going to undermine prisoners' rights.
Thank you very much. Now Martha is going to tell us about the judicial review proposals in a bit more detail.
I've done a note setting out some of the concerns about the judicial review proposals and the residence test proposal. They're really just off the top of my head key concerns. It's not exhaustive or definitive, but it's intended to help people when they're sort of sitting down to do their responses. As Laura outlined, there are two main proposals in relation to the funding of JR. One much more serious than the other. The first is that there will be no payment for work done pre-permission if permission is not granted. If you settle your case, you will have to go after the other side for a costs order. The second proposal is that borderline cases will no longer be eligible for legal aid. I'm not going to deal with that proposal in much detail. I'm not dismissing it, but I think the consensus is that it's probably a fairly academic distinction when you have a borderline case anyway. So I'm just going to focus on the no payment for pre-commission work. The headline point with this is about the rule of law and about government accountability. There will be a chilling effect on judicial review if lawyers are not paid for their pre-commission work. I'm preaching hugely to the converted here, but it's obvious why. One of the reasons is that legally aided JR is not financially viable now. It's recognised as not being financially viable. It's been recognised as that by the courts. I was looking through some of the costs case law, and this is what Lord Hope said in the JFS case. It is one thing for solicitors who do a substantial amount of publicly funded work and who have to fund the substantial overheads that sustaining a legal practice involves, to take the risk of being paid at lower rates if a publicly funded case turns out to be unsuccessful. It is quite another for them to be unable to recover remuneration at inter partes rates in the event that their case is successful. If that were to become the practice, their businesses would very soon become financially unsustainable. And that's recovering at legally aided rates. And these proposals are to say no recovery whatsoever. So in your responses, don't say this will make legally aided JR not financially viable. It already is not financially viable, and this will make it worse. And what that means is that solicitors won't take on the cases. They won't take on the meritorious cases. Because, of course, even if you had a case where you thought it was a 90% success rate, and you only ran 90% success rate JRs, which in itself is a fiction, but even if that were right, you're looking at losing 1 in 10 cases. So you're looking at a 10% across the board cut in your fees, which you probably can't afford. There are also huge practical difficulties that are unique to judicial review that makes doing work at risk unfeasible. Firstly, permission is a total lottery. The Public Law Project have done some research on this. There's lots of information on our websites in a report called The Dynamics of Judicial Review. And you can see, and anyone who's ever done a judicial review will know, that depending on the judge, on how experienced they are, on what their prejudices are, you may get permission and you may not get permission. Making that judge the sole arbiter of whether you get paid simply isn't fair. Similarly, there are evidential issues around JR which are unique to JR. Again, everyone will know it's very difficult to assess the merits of a judicial review right at the outset. Routinely, you do not get the evidence that you need until the acknowledgement of service, or even until after you've had permission and you get proper evidence put in. Similarly, there are levels of uncertainty to bringing a JR that don't exist in other areas. Time limits are a perfect example of that. The requirement to bring a case promptly means that there is always a little bit of uncertainty about whether you will lose simply on that prompt process point, not on the merits of your case at all. And with the best will in the world, you might think you brought your case properly, but a judge, because of the permission lottery, might think differently. Similarly, it's certainly my experience, and I imagine it is yours too, that post cases like Barter, there are now situations where the other side will make an offer of settlement on the condition that there is no award for costs. Now, if that is right, there is going to be a huge conflict between solicitors and their clients, because what the other side will say is, we will settle favourably for your client, but we won't pay your costs. And how is the legally aided solicitor, if these proposals come into force, how is that solicitor supposed to resolve that conflict? I'll look a little bit in more detail at the bogus statistics that Chris Grayling likes to bandy around. There's a paper that goes into this. I think it's in your pack, but if not, it's, so yes, it is in your pack. It's also on the PLP website. And this is the work of the research director at PLP, who looks into public law and public law remedies. So on Radio 4 on the 23rd of April, and this is a really unpleasant thing to wake up to if anyone did, Chris Grayling said that of the over 11,000 JRs that were brought a year in 2011, only 144 were successful. And so he said, we're not saying that there shouldn't be judicial review. We're not saying that members of the public and organisations should not be able to challenge public bodies, but what we're saying is that we have to raise the bar so that we have fewer cases that have no chance of succeeding. Only a glance at the published statistics from the MOJ show that that figure is totally misconceived and misleading. So the headline point, and like I say, this paper goes into more detail, but the headline point is that that figure, saying that only 1.5% of JRs succeed, completely disregards settled cases and a whole tranche of cases that just seem to disappear from the official figures, and we have no idea what happens to them. So thousands of cases settle. Of the cases that settle, PLP's research shows that 75% of them settle in the claimant's favour. So it must have been a meritorious claim. Of the cases that go forward, and I'm going to remove immigration and asylum from this because they will in the future all be in the tribunal, and those statistics do muddy the waters a little bit, although they don't go so far as to make it as bad as Graham says it is. But removing immigration and asylum, there is a 50% success rate for claimants in civil JR at the commission stage. 50% is high. When you look across other areas of law, that's a really good figure. There's also no way of telling from these statistics how many of these JRs are brought right with legal aid. No way of telling how many are litigants in person, no way of telling how many are train companies judicially reviewing the government or care homes judicially reviewing about their fees. Those JRs that do go to the final hearing, again, removing immigration and asylum, there's a 40% success rate. Again, this is a high figure. That's the same figure as the success rate going to the Court of Appeal. And no one in their right mind, although possibly this Lord Chancellor, but hopefully no one in their right mind, would ever say that that would mean we should just get rid of legal aid for appeals, because 40%, well, what's 40%? The reason this statistic stuff is important is because this consultation is based on those figures. And in meetings that we've had with the MOJ, they have cited again and again this figure of 144, 1.5%. If this consultation is based on that, then in pure public law terms, that is an irrelevant consideration. And it is not a basis on which a policy should be made. So I think the first thing you should say in your consultation response, if you're going to make one, which I hope you will, is that this is a complete sham. And until they come forward with some evidence that can actually be relied on, we can't even really respond properly to this consultation. I'm not going to talk about the fee cuts. I think they are important. I think they're issues of equality of arms. But I've touched on it in the paper and we don't have much time now. So I'm just going to move on to the residence test. This is a two-limbed test and this is really pernicious. You have to be lawfully resident at the time that you make your application for legal aid, and you have to have been lawfully resident for a continuous period of 12 months at some other point. The legal aid provider will be responsible for keeping the evidence on file of lawful residence. There are two exceptions: asylum seekers and British Armed Services personnel who are currently abroad. You can imagine how huge this exclusion is. Anyone working with foreign national prisoners, anyone working with migrant families, anyone doing community care, immigration detainees, all of that will disappear. There are two tranches of argument you can make, I think, against this proposal. The first is that it's unjust and it's contrary to the rule of law. And the fundamental point there is that basic to the rule of law is equality before the law. And if you start removing whole classes of people from the protection of the law, then you cannot be said to be upholding the rule of law. There will also be no legal sanction for ill treatment for these people. So there'll be fair game. There'll be fair game for the police. There'll be fair game for the authorities that are deporting them, because they won't be able to bring a civil action. Nothing. It's also, these are the most vulnerable people often in society. I do a lot of work with destitute families, and again, you'll all know that these people are right at the sharp end. There are lots of primary statutes in this country designed to help those people. The Children Act, the Equality Act, the National Assistance Act. Those statutes will be completely emasculated by this proposal. It's also, I think, completely unworkable. As I said, solicitors will keep the evidence of lawful residence on the file. And as any immigration solicitor knows, the question of lawful residence is simply not a straightforward one. There are hundreds of examples, and if you want more, I suggest you look at the ILPA website because they've got a very detailed briefing on this. But, for example, what will you do, and this is perhaps an absurd example, but bear with me, what will you do if your client says, well, I'm here now lawfully, and back in the 1950s, I was here lawfully for 4 years. You, be you family solicitor, immigration solicitor, public lawyer, whoever you are, you're then going to have to work out how to prove that from 1954 to 1957, your client was lawfully here. Similarly, There are lots of occasions where lawful residence vests by operation of law, nothing to do with documentary evidence. So, for example, Zambrano carers, who, by virtue of EU litigation, are here because they have a British child and they're the primary carer for that child, but they're a third country national. How will you prove that that's what this person is? Because that's something that comes in as soon as they have that British child. It's nothing to do with whether they've got a stamp on their passport. And in fact, in this country and in the EU, there's no way of stamping people's passports when they go in and out of countries. There'll also be absolutely absurd situations. So the Zambrano carer that I referred to won't be able to get legal aid when her daughter is 11 months old, but will be able to get legal aid when her daughter is 1. Similarly, British children who aren't a year old won't be able to get legal aid. Workers who are lawfully here because of free movement rights, but have only been here for 11 months, won't be able to get legal aid until they cross the 12-month threshold. I think this will result in a huge amount of satellite litigation. I think there's lots of questions about whether it's even lawful under human rights law and under EU law. We don't have time to go into that. But I think the headline point is that this is going to be very expensive and it's going to be impossible to police. The only other thing I would add is that I think it's worth flagging in consultation responses. You will have looked at the impact assessments that accompany the consultation document. They are absolutely sparse. And I think it's also worth saying that how is it possible to do an impact assessment of proposals that are going to be brought in months after the biggest change to legal aid that we have had in decades? Finally, I was just going to add another diary date to Laura's list, which is that on the 20th of May, after the London Legal Walk, there's going to be an event at the LSE, which is coordinated by Matrix Chambers. It's chaired by Conor Doughty, various people are speaking at it, and again, it's to kind of raise awareness and discuss all these issues.
Just to highlight to you, you've got at the back of your pack on Annex 4, you've got links to lots of the things that Master was talking about there, so that you can follow up. And now I'm going to hear from the Prisoners Advice Service.
Firstly, just from the show of hands earlier, I'm obviously aware of just how many prison law practitioners are here in the audience, and probably a lot of what I'm going to be saying is going to be very obvious to you, and I will try to avoid duplication of issues that have already been made. I thought I'd start just with a little bit of the history of the Prisoners Advice Service, because as Philippa did, I think it is instructive as to look at where we were when the Prisoners Advice Service was established, as to where we might be going if all these proposals do come in. The Prisoners Advice Service was launched as an independent charity in 1991 against the background of the Strange Ways prison riots in 1990 and the 1991 Wolf Report that came out looking into the causes of the disturbances. And clearly one of the big issues there was prison conditions at the time, and it was seen that there was this need by 10 penal reform and legal organisations to establish an organisation that could meet this unmet legal need of prisoners, to try and give them a voice and to push for reform within, through legal means, through the prison system. Now we are in a situation where there are duties of disclosure on prisons and the Parole Board. Policies are available on the Ministry of Justice website, largely due to the work of the prison lawyers that have arisen over the past 20 years. But without legal scrutiny, there's a clear danger of a return to a much more closed landscape. And there's such an evident problem of the how prisoners can actually use all these gains that have been made in the last 20 years, when so many can't effectively access, understand, or even use the information that is available to them. And clearly anyone working in the area of prison law is aware of the problems regarding the effectiveness of the prison complaint system and the prison information ombudsman as a solution to all the problems they have. So, in terms of how we're funded, we have a standalone prison law contract in addition to associated contracts that allow us to bring
discrimination claims and judicial reviews. In addition to this legal aid funding, we do receive funds from independent sources, from charitable trusts and foundations, which does enable us to do pro bono work in a way that purely commercial firms obviously cannot. However, we will be under severe pressure and too, with all these changes that are coming in. Well, they are saying they're consulting on if they do come in. And obviously the service that we offer will be under extreme and increasing pressure. In terms of the impact of the changes, which is what I'll come on to, in terms of the scope and the changes there, as we've heard, effectively they've drawn a line as to which cases will still receive funding, to those which engage Article 5 and the right to review of ongoing detention in Article 6. That's effectively going to be parole minimum tariff cases, independent adjudications, or those internal adjudications with representation and deterrent principles. So I'll look at the other matters which are now going to be out if these changes come through. Categorisation reviews, allocation in mother and baby units, all those kind of issues, which clearly often raise complex legal issues, not just of procedural fairness and public law principles, and other articles of the European Convention on Human Rights. And we would say these are obviously issues where decision makers can clearly be assisted by proper legal advice. For example, if you look at the case that we brought in 2012, this was a challenge MPMP to the Secretary of State's policy on childcare resettlement leave. We successfully challenged their policy, and in a very strong decision, the court held that the Secretary of State had to have regard to Article 8 and the best interests of the child when making decisions about childcare resettlement leave. And that is a case which has changed that policy for so many women who have children who are within the prison system. Now that's a case that would have been very difficult to actually bring to court if there was just no funding there available to do the huge amount of work that was done prior to bringing that case to court. In terms of release on temporary licence, there's also been other cases that we've brought over the past couple of years. In addition to childcare resettlement leave, there was a challenge of the policy that no lifer in Category C conditions could be released on temporary licence, save for exceptional circumstances. That was challenged. In that case, it was a prisoner who couldn't be transferred to open conditions for medical reasons. Another challenge that was brought is how bottle eligibility dates are calculated for prisoners who had confiscation proceedings ongoing. In all of these cases, the complaints procedures were used and the complaints were either dismissed or no adequate response was received. And in all of these cases, the client eventually led to a change to the policy as a result of that. In fact, all of those cases are reflected in Prison Service Instruction 21, 2012. So there's clear examples of how government policy are changed by cases that do not arise from issues that would now be, that are now in scope but would no longer be. With respect to mother and baby units, the placement of mothers in mother and baby units is not automatic, and often representations need to be made on their behalf to really put in the front of the prison's mind the need to balance the interests of the mother and the child against their perception of, say, behaviour, assessments of risk, things like that. And often representations can make a real difference to the decisions that are made for those mothers and their babies. We've had a case where a mother was sentenced to a term of imprisonment. She had a 2-week-old child and she was breastfeeding. And the prison just refused to do an urgent assessment. They said, oh, you know, just go through the normal process, it will take weeks. And they refused to do an urgent assessment of her need for placing the mother and baby unit, despite the fact that the sentencing judge had made specific checks prior to sentencing that in fact Holloway did have a mother and baby unit that she could have access to. Urgent JR proceedings that immediately led to a positive decision, and she got her placed in the unit. Again, that's a case which the initial work that was put in would not get funding in terms of trying to negotiate with the prison. And I think that the point that Laura made is very important, that whilst ultimately the judicial review case that is brought can get funding, the work that is funded by the prison law contract is essential as a gateway to actually bring these cases to the point where they can be challenged by way of judicial review decisions, and also to make sure that they are properly set up for a judicial review challenge. In terms of resettlement, we have a specialised community care caseworker, and just due to the nature of the prison population, the cases we deal with often involve extremely vulnerable prisoners, and their access to and provision for their care needs on release under the various community care legislation. It's often necessary to make quite complex legal arguments to both people within, say, the prison service or probation who don't understand what rights these prisoners have under the various community care provisions for them, and the need to signpost them earlier, to start asking the local authorities to actually start assessing them for a proper release plan. But also, the local authorities often try to dispute ordinary residence issues, saying that they're not living in our area, they're not our problem, contrary to the Department of Health Ordinary Residence Guidance. These are all complex issues. There's no way that prisoners can actually, first of all, understand what their rights are. I mean, often, as I say, even the authorities are not aware of the provision that could be out there for them. But there's no way that prisoners could actually tackle these issues themselves without legal assistance. And again, all those issues be out of scope. And I think it's also those kind of issues that do highlight the arbitrariness of just saying, well, yes, we will fund parole, but we won't fund all these other issues that feed into the point of release, both having robust release plans, but also sentence progression, so how prisoners actually progress through a sentence to get to the point where realistically they might actually be able to get released. So in terms of the kind of sentence cases, even those that are within scope will have to go through the complaints procedure. So even if they do engage Article 5. And there is a question of when Article 5 is engaged for indeterminate sentence prisoners. It's complex issues. James and Wells suggests access to courses only becomes an Article 5 point post-tariff, and even then after a period of time. So even post-tariff, how long do you have to wait to see Article 5 is engaged? And obviously, somebody may have spent years in the prison system pre-tariff, not getting access to their courses, not getting the progression that they need, so that they have to wait until they're actually post-tariff before they can actually get the legal assistance they need to start progressing towards relief. And that's clearly serious issues there. How are we time? Yeah, so I mean, that's just touching on, there's so many more that could go through. There's category A decisions, categorisation decisions, I mean, clearly, again, categorisation. Indeterminate prisoners do not get referred to the independent adjudicator because they can't get additional days. So they actually have internal adjudications. Our experience totally backs up that of Laura in terms of prisoners not being granted, even where they have been, it has been asked for representation under the Tarrant principles, not being granted legal representation. and never experiencing a prison governor proactively seeking it on behalf of a vulnerable prisoner. But clearly you have these indeterminate sentence prisoners who then can have internal adjudications without the benefit of any legal assistance with that. And we had a case recently where there was a life sentence prisoner who was very close to their parole. They had 2 adjudications, internal adjudications they were found guilty on. We got them quashed on appeal, which obviously we did under legal aid funding, and they were released at the subsequent parole hearing. And if they still had those 2 adjudications on their record, that would clearly have been relevant to the assessment of risk that they posed, and clearly might have had a serious impact on the outcome. So I think I'll just wind it up there, but I would just sort of throw out, because obviously we've heard a lot about the consultation, and we're here to think about how to respond to that consultation. But I'd also just like to throw out as a thought, this is a discussion for people to think about. There are additional responses than just responding to the consultation, and kind of ideas people might want to discuss as we open up to discussion are things like striking and unified refusals to sign contracts. Obviously these are very difficult to engineer, but when we start looking at the alternatives, when you look at the determination there appears to be to go through with these proposals, really have to start looking perhaps at some fairly radical alternatives to think how to prevent us from all walking into unacceptable, unworkable, unfair and potentially unlawful proposals that have been put forward. Okay.
Thank you very much.